Hi everybody, Dana Sparks, continuing on with the video series on the mid-year revisions that the Georgia Association of Realtors has made to their contract package. Dana Sparks, broker of Maximum One Greater Atlanta Realtors and director of the Real Estate Academy of America. If you have questions about either of those entities, please feel free to reach out to me, as I'd love to share information with you about those. Moving on or continuing on, this is a mini series that I am doing on the revisions that the Georgia Association of Realtors, GAR, has made to their contract package. They release a new contract package in January of every year, and then they typically do mid-year revisions to just look at syntax errors, grammatical corrections, spelling, things like that. Every now and then they put in some pretty important conceptual items. Sometimes they just add information to clarify concepts, but they have done that, and those revisions were released in June 1st of 2023, and I'm covering those in this mini video series. So please check out the other videos I have done on some of the changes that GAR has made 2023 mid-year, as well as everything about the GAR contracts, as well as other information such as license law, all that kind of stuff within this YouTube channel. So I am going to continue on. Today I am going to talk about some of the other forms that GAR has made their changes to. And in all, GAR made changes to 20 forms. I have already done a separate video on the changes they made to the purchase and sale agreement. And if I didn't mention it in that video, the changes they made to the residential purchase and sale, they've also made to all the purchase and sales, land, lot, new construction, so forth and so on. I did another video on the changes they made to the brokerage agreements and the authorization to show unlisted property. In today's video, I'm going to cover some of the other ones. I'm going to cover the termination, unilateral TNR, the temporary occupancy agreement for seller after showing, the VA loan contingency exhibit, and the 2 forms regarding the attorney as holder of earnest money. In addition, I am not going to do a video series or videos, but they have also made changes more than just what I've mentioned to the lot purchase and sale agreement, the land purchase and sale. The lot purchase and sale agreement is F210. The land purchase and sale agreement is F213. The new construction purchase and sale agreement is F228. I am not going to cover those in depth. Some of the other forms that they did revise, again, are just updated, corrected names and footers, fixing paragraphs. It starts a paragraph on one page, but the verbiage is on the next page, things like that. I'm not going to cover that. But let's dive in and let's start with the temporary occupancy agreement. So I have found that the best way to go over contract changes, rather than just blah, 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 telling you what they are, is to actually show you the changes within the context of the form. So I'm going to share my screen and let you look along with me so you can see what it is that I am talking about. So in general, wherever it is that you access your contract forms, you will see this 2023 GAR forms revision package, and this does outline all of the changes GAR has made since January. And again, as you will see, some of these, they've just changed the paragraph numbers for syntax and some issues like that. But let's dive in on the temporary occupancy agreement. This is temporary occupancy agreement for the seller after closing. And again, you will know that it was changed mid-year because of the footer. It will have the date 6/1/23 rather than 1/1/23. And the only thing they changed in this is under paragraph 11. It talks about if a seller becomes a tenant at sufferance, meaning the buyer and seller negotiated for the seller to stay in the property a certain number of days after closing. If they fail to vacate after that agreed upon time frame, and that's agreed upon right here, then they owe the buyer, who is now the owner of the property, a dollar amount for being what is considered a holdover tenant or a tenant at sufferance. And this paragraph 11 goes on to explain all of that and the legal and financial ramifications for a seller not vacating when they said they were going to. What GAR added in June of 2023 is they've added this phrase that the seller shall be liable to the buyer or liable financially for damages and including and those are financial damages, including actual attorney's fees reasonably incurred. In other words, if the buyer has to hire an attorney to actually evict the seller from their home, that seller, who is now a tenant at sufferance, is responsible for those attorney's fees. So that's the one addition they made to the temporary occupancy agreement. Let me show you. I love this change. This is the unilateral TNR. T stands for terminate, R stands for release, but it is Form F-522, the unilateral notice to terminate purchase and sale agreement and proposed disbursement of earnest money. As you have heard me repeatedly teach in my classes and on these videos, GAR has these two completely separate, well, not completely, they're related, but they are separate contractual issues on one form. The termination of a contract is one issue, and then what happens to the earnest money the holder is holding is another issue. A termination of a contract may be unilateral. And it always got confusing because in the unilateral notice to terminate, GAR had two signature lines and it said seller and buyer. That got really confusing because once a party signs this, it's unilateral notice. You only need one party signature, one side signature. So it had buyer and seller, and there was a lot of confusion that if only one side of the transaction had signed it, was it actually terminated or not? And the answer, of course, is yes, it was terminated. So GAR has, thankfully, we love this, cleared up this confusion by taking out two signature lines. I mean, they've got two signature lines, but it's for one side. And it just says signature of party giving notice. It doesn't say if it is specifically a buyer or specifically a seller. Now, as you know, also on this is the proposed disbursement of the earnest money. And per license law, it does, as well as per the contract, it does require both party signatures, both sides signatures, written agreement for the holder to release the earnest money. So that is why it says buyer, and those are for the buyers in the contract, and seller, and it does have and here. So both side signatures are required. That has not changed. What did change is now this only has one side's signature line. Love that, Georgia Association of Realtors. Thank you, thank you, thank you. Now let's look at the VA loan contingency agreement. This is GAR F410. Again, you know this is the revision because it has here June 1st, 2023. And the only change they made is under the section in the VA loan contingency exhibit, paragraph 15, where it talks about the termite letter. None of this has changed. So a lot of this was changed in January of this year, but for the June mid-year revision, none of this was changed other than basically one of the major changes in January is that a termite letter may be paid for by the buyer or seller. So you need to negotiate that up front. If, however, there was previous damage or it is discovered that there's damage by termites and that gets corrected and a new letter is issued, any reinspection fee necessitated by seller correcting infestation from termites and other wood-destroying organisms shall be paid for by seller. That has been there. What they added in June is that this fee that a seller pays for any re-inspection or updated letter, that seller fee is paid in addition to any contribution at closing. So if a seller is making a contribution to a buyer's closing cost, that fee for that updated letter is in addition to any seller's buyer's closing costs, contribution to buyer's closing costs. And then the last two forms I want to cover have to do with the closing attorney as the holder of the earnest money. And there are two, if the buyer and seller negotiate to have the closing attorney hold the earnest money in a transaction, there are two forms that are required. This is not new information, everybody. There's one that is F510, which is an exhibit to the contract. This is where a buyer and a seller identify the closing attorney who is to act as the holder of the earnest money. They identify the closing attorney here. This form is initialed by the buyer and the seller. None of this has changed. It talks about time frames and so forth and so on, an alternate holder. Just so you know, while I'm here, if it is an all cash transaction and it fails to close, a closing attorney as holder of the earnest money, if buyer and seller don't agree on the disbursement of the earnest money, it has to go to court. A closing attorney as holder of earnest money in an all cash transaction is required to interplead the earnest money to a court. And there are fees involved in that. So you guys, if you're doing an all cash transaction, you want to really think about if you want a closing attorney as a holder of the earnest money or one of the brokers in the transaction. That's not new. That's just because I'm here on this form. What the Georgia Association of Realtors, or GAR, did change in June of this year is the time frame within which the closing attorney must agree to fulfill the responsibilities of holder of earnest money. It used to say 3 business days, and they have changed it into 5 business days. So again, this is GAR F510, an exhibit initialed by buyer and seller. And what got changed is this paragraph 3, the closing attorney must agree to become holder within 5 business days of receiving the contract. And it used to say 3. Then the related form is form F511. This is not an exhibit. This is agreement of closing attorney to serve as holder of earnest money, escrow agreement. This is signed by the closing attorney. Buyer and seller do not sign this. It is not a part of the contract. This is just an agreement signed by the closing attorney agreeing to fulfill all the responsibilities as holder of earnest money as outlined in the contract. And again, what got changed in June of 2023 is the time frame that the closing attorney must sign this form to become holder of the earnest money within 5 business days. It used to say 3, so that was changed to paragraph 2. And again, if the closing attorney fails to sign this agreement and does not become holder of the earnest money within 5 business days, then the alternate holder that was named in the exhibit, which is form F510, becomes the holder. So again, what got changed in June is the timeframes. If you want more information about closing attorney as holder of earnest money, or any of these other contract forms, I have done a ton of videos on the GAR contract package, as well as the RE forms contract package. We teach CE classes on this, so please check out the videos. Check out our link below, our calendar for the Real Estate Academy of America for our CE classes on contracts, as well as a myriad of other topics. And I hope this video tip, this series, helped you out. I appreciate your time, and thank you so much for watching. Dana Sparks, broker of Maximum One Greater Atlanta Realtors and director of the Real Estate Academy of America, satisfying your needs with service, innovation, and education. Bye. If you like that video, check out the one here. If you like the content on this entire channel, please click here to subscribe. I try to take even the most complicated of real estate situations and make them crystal clear. See what I did there? Real estate made crystal clear. Thank you guys so much for watching.